All right. Now that we have audio on the live stream, I'm not going to repeat all that. Hopefully they can read lips. And so be sure and turn your cell phone to the off or silent position. Trying to think, we do allow people to move around the courtroom during the arguments, but be respectful of the person that's doing the argument so that you don't interrupt them or break their flow. Gentlemen, anything else you can think of that I need to? Okay. All right. I know that in the second case, there is a exhibit for use at oral argument. I'm going to need to make sure that there's no objection to that, but at this time, we're going to take announcements in the two cases. We've got Clay versus the state of Texas.
Cynthia Orr here with John Gilmer and Aaron Diaz and also Robert Stem. I will be arguing exclusively Chief Justice Gray when we're ready to proceed.
I got Orr, Stem, and Gilmore and
Aaron Diaz.
Aaron Diaz. Okay. I don't have you on the list of counsel, but since you're not going to be arguing, that's okay. But stop by and see the clerk if you want to be on the docket so that you get notices and stuff.
You get a certificate?
A certificate? Oh yeah, exactly.
Oh, that's terrific. Thank you.
State of Texas, President ready. Sterling Harmon will present argument on behalf of the state.
Okay. No trial exhibits or no exhibits for
State, Your Honor.
Okay. All right. Thank you, Counsel. We'll get to y'all in just a minute. The other case on the docket for today is a mandamus proceeding in Re H&S Hope Ranch LLC.
I'm Scott Field here for Oak Ranch with my co-counsel Bill Youngkin. If I could just introduce, where I've got two people here watching who it's their first time in the Waco Court of Appeals. Marshall Bowen, who's my colleague at Butler Snow, who just finished a clerkship at Texas Supreme Court of Criminal Appeals, is here. And Victoria Peloso, who graduated from Baylor Law a week ago, is joining us in the fall and wanted to come watch today.
Okay. Very good to have y'all. Thank y'all for coming.
Good morning, Tom Forrest here, the Real Party and Interest of Rebuttal LLC, and we have no objection to the exhibit.
Okay. Thank you, Counsel. We will, as I said, we will take a break between the cases, wipe down the table and the lectern for y'all. And the timeout allocation is 20, 20, and 5 for rebuttal. There are 22 issues. And so we may or may not adhere strictly, but anticipate that you won't get any extra time, but that we will be considerate of the number of issues and what needs to be argued. So, and you may approach the lectern. Anything else? Okay. Counsel, you may proceed when ready.
Good morning, Chief Justice Gray, Justice Neal, and Justice Rose, Mr. Harmon. My name is Cynthia Orlock, along with John Gilmore and Aaron Diaz. I represent Tyler Clay in this case. I'd like to start with structural error in this case. That is the elimination or recusal and disqualification of Jessica Freud, who was counsel in this case for 1.5 years, assisting Mr. Schaefer. And to suggest to the court this was structural error and it was unnecessary. Mr. Schaefer, who was co-counsel and lead counsel in the case, knew nothing about Ms. Freud's client, David Mims, who was a witness for the state. He was going to cross-examine this individual, and the rug was pulled out from trial judge in this case when the state did not call Mr. Mims as a witness in this case. And I think what's really interesting is that at page 64 of the state's brief and in the record at volume 11, page 15, the state noted that the trial judge was not going to allow the testimony of Mr. Spears because Mr. Spratt, who was relaying the hearsay, had not been sufficiently corroborated. That's at lines 6 through 10 of volume 11, page 15 of the record. And so the state at 64 of their brief also says, well, we've also felt that the judge would not allow David Mims' testimony either. And this is exactly what Mr. Schaefer suggested, that Mr. Mims was not going to be called as a witness. His testimony was cumulative and was adverse to the state's theory of the case as well. So that structural error existed. It was unnecessary to disqualify Ms. Freud. I'll just, because I think grouping these issues help the court, we were talking about how the judge at page 15 of the record, volume 11, indicated that the accomplice witnesses had not been sufficiently corroborated to admit. That's one of our issues for reversal and rendering of this case, and that is indeed a fact, that they were not corroborated, that evidence of motive, which was in the record and pointed to as how somehow corroborating, isn't sufficient. You have to show that Mr. Clay was tied to commission of the offense. Evidence corroborating what an accomplice had said, that a kite note was sent between the jails, or that they were in the two people that communicated were in the same jail facility at the same time, is insufficient to corroborate an accomplice witness. And raising a suspicion with Daquana Gilmore's testimony saying that she somehow was making a call for Mr. Clay to ask Mr. Spratt to stop speaking, which I don't agree that's a proper interpretation of her testimony, but let's say it is that way. That raises a suspicion about Mr. Clay only. It does not tie him to commission of the offense.
Counsel, let's go back just a little bit.
Sure.
On the same issue, because I'm having trouble wrapping my brain around the assumption that Spears is an accomplice.
Right, well, Mr. Spears, I think, was the theory of the conspiracy was that Mr. Spears was first contacted to kill Mr. Pittman, and he was arrested before he could accomplish that goal. And so then this would be a conspiracy to kill Mr. Pittman, and then Mr. Spratt was allegedly hired to kill Mr. Pittman and was successful. So
And there was about a month delay between when Clay had his conversation with Spears and when the death took place, the murder took place.
that sounds about right, because I
So
think
I'm trying to figure out,
Mr.
is there not a natural break there? That
There
this
is.
one event and this is a second event and this had nothing?
There is, but they're accomplice, I guess, in two different conspiracies. And that was one of the problems that we had, because the state argued vociferously that these were all connected, that was in fact contextual evidence. And Mr. Schaefer made the point that no, these were two separate matters. And so I think we have arguments both ways from the state on that, because they also argued the accomplice witness instruction should not have been given because these were two separate matters. So it's all in how you view whether the conspiracy to kill Mr. Pittman was one overarching conspiracy or two separate ones. But certainly Mr. Clay and Mr. Spears and Mr. Clay and Mr. Spratt are accomplices no matter which conspiracy theory you buy, if you buy the state's theory. And so an accomplice witness instruction was important, and they needed to be corroborated, certainly, and they were not. The judge found that, the trial judge did, and I think the evidence in the record bears that out.
This is organized. So between Mr. Spratt and Mr. Spears, is there anything in the record showing coordination or communication? And sort of secondly, is there any requirement of that going into the accomplice analysis as whether they were accomplices?
I think because we're looking at an accomplice relationship between the defendant on trial and the individual, that no, we don't need to show that coordination, Justice Rose.
I assume there's nothing in the record to show the coordination.
There is, because they say they're running buddies. There's testimony that they were also talking about committing another murder together, the Anderson murder that came up in this case as well. And then they start speaking to each other in custody, and there appears to be no apparent reason for that communication if they weren't coordinating. So there does appear to be testimony about them coordinating the hand signals with each other, sending kites to each other, and then actual meeting in the rec yard, depending, even when they're going to different facilities. So there's evidence of some coordination on that part, but not before Mr. Pittman's killed. I'll then go.
With regard to the corroboration, was an accomplice witness instruction given in the
It
charge?
was.
Did it include jailhouse informant testimony?
Boy, I haven't read it in a
Corroboration.
while. Chief Justice Gray.
But that's not part of your argument or reliance upon the fact that the testimony between Spratt and Spears about the hand signals and the communication, you're not relying upon that testimony being taken out in considering Clay's connection to the offense by it being jailhouse testimony.
That was not raised below in the case or the
Okay.
briefing, Chief Justice Gray. But then what couples into that, and what's really important here, and the coordination is important, Justice Rose, because what we're talking about whether these statements from Spratt to Spears was testimonial, we need to look at that for the confrontation violation.
Can you give us it would be helpful to us to have the issue number that when you, if you have that readily available. That's okay. If you don't have it already in your notes.
I will give it to you. So I sort of have combined several of these so I can argue them on. My colleagues will get those for me and I'll advise the court. I think what I had sort of missed when we were briefing all this that I adverted to preparing over the last few days was the Langham case out of the Court of Criminal Appeals that I will put in a letter to the court after, but it's at 305 Southwest 3rd, 568. It's a 2010 case out of the Court of Criminal Appeals at 579, where the court says, when we look at whether something's testimonial, we look at what the receiver of the information is receiving that information for. So we need to look at why is Spears getting this information from Spratt? And we know Mr. Spratt was arrested in January of 2016. And then Mr. Spears is, who was already in custody, having not been able to accomplish the killing of Mr. Pittman. He's already there. He was I think arrested in December of 2015. And so Mr. Spratt joins him in January. And what does Mr. Spears do? He testified that he wrote to Detective Thompson in January of 2016 to tell her, I have information for you about the Pittman and the Anderson murders. And so the purpose that he was gaining this information from Spratt was to relay it to the detective for use in a court proceeding. So we have clear information from his testimony about when he wrote the letter telling Detective Thompson, I have information about this murder for you, that he's gathering that information to relay it for purposes of trial. And so we have a testimonial statement.
Spears.
That is Spears. He's receiving the information. The Langham case says that's whose intention you look at to determine if it's testimonial. And then he said, I related to Thompson in a letter in January. Then he, and these are points of error 16 and 1 through 3 that I'm arguing together, Chief Justice. Right. And so the state then says, well, you know, these are co-conspirator statements. Let's forget about the testimonial part. These are co-conspirator statements, so they're not even hearsay. And we know also from the testimony that the conspiracy was over. Mr. Pittman was deceased. There was nothing else to be accomplished in the conspiracy to kill Mr. Pittman. And so we know that, and the prior conspiracy that you asked about, Justice Rose, that was failed by Mr. Spears, that had concluded by its failure. According to the state, they conceded that in 12 Record 252, that had concluded with failure. So
I was thinking that the law was that a conspiracy continued for the cover-up as well.
And the law is to the contrary, Chief Justice Gray, that you know, a discussion of past conduct in the Gidrick case, that does not indicate that the conspiracy continues, that there's payment still due and owing to the hitman, so to speak. That does not continue the conspiracy, and that the The cover-up afterwards is also not considered a part of the conspiracy, according to Texas and federal law regarding conspiracies continuing. And that's and also in the Deed case, the Krulwich case, and these are in brief,
Okay.
and the Gidry case. So that is, I understand that was the state's theory, but that's not the law. So it doesn't get in under that theory. And then Texas, according to our rules of evidence that specifically say that the objected to hearsay, and this has to do with the use of this testimony when it finally came in, objected to hearsay does not have probative value. If it's unobjected to, it might, but Mr. Chafin objected on every occasion. And then Texas adds another component. Let's say it wasn't testimonial. But as I said, it clearly was, and I don't agree that it was not. But in the Crawford case out of the U.S. Supreme Court, the court said that non-testimonial hearsay is something that we have flexibility for the states developing their own hearsay law. And so the continued viability of Roberts and the requirement for reliability still continues in Texas. Texas does still adopt that law. We don't allow, for example, outcry statements from children unless the child testifies, regardless of who that statement's made to, even if it's not testimonial. And so we require in Texas this continued requirement of reliability when we have this sort of hearsay that we're determining whether it's going to be admissible under the confrontation clause. And so under the Austin cases, the Miles case, the Stealing case out of this court, this reliability is absent. Why? Because we're in the blame game here. We've got Mr. Spears saying, I didn't do the murder, Mr. Spratt and Mr. Clay did. And then we also have Mr. Spratt saying, well, it wasn't my idea. It was Mr. Clay that ordered this killing to occur. He's shifting blame as well. And when we have those kinds of cases where someone's shifting blame and denying their own responsibility, those are inherently unreliable statements. Under Illinois versus Lee and the line of Texas cases and the Austin Court of Appeals case affirmed by the Court of Criminal Appeals in Davis, that when we have this unreliable kind of statement, then it violates the confrontation clause to allow it in without cross-examination of the speaker. So for all these reasons, those statements should not be admitted. It was suggested by the state that Mr. Schaefer opened the door to this testimony because we know that Judge Johnson excluded it, saying it wasn't sufficiently corroborated initially, and then he later let it in. But what Mr. Schaefer argued, and he's correct, it's replete in the record, that he was refreshing the witness's memory, that he did not mischaracterize his testimony by suggesting that he was only there to do his, get a favor for himself and leniency. He opened his questioning with Mr. Spears saying, isn't it true you interviewed with Detective Thompson about 2 murder cases, the Anderson murder and the Pittman murder? He asked those questions at volume 11, page 296, and at volume 11, page 303. So he wasn't mischaracterizing the purpose of the interview. And the state began their direct testimony of Mr. Spears by asking, so when you testified here today, it's just from your memory. You didn't review your recording with Detective Thompson. And he says, yes, that's right. This is just from my memory at 11 record 207. And so do you remember the time frame, they asked him at page 208? Do you remember when you first tried to contact her at page 208, line 17? And he's recalling January. And did Thompson come right away? And she came a second time. She came in January or February, and then she came again because he had requested a lawyer. And she said to him, you didn't write it down in your date book, did you? This is from your memory. And he says, yes, that's the case at page 231. And so when Mr. Schaefer asks questions, he says, oh, you can't remember? Let me approach you with this transcript of that recording. And he said at page 256, I don't remember the date. and he refreshed his memory. At 3:07, I don't recall what I was speaking to her about, and he refreshed his memory. At 3:15 of that volume, I can't remember what deal I spoke to her about. And Ms. Laborde's objection to that was, he can't remember. He answered you, he can't remember, at line 15 of page 315. So his entire direct and cross-examination was about his memory. And that is what Mr. Schaefer stuck to. He mirrored that direct testimony. And he, when asked about were you paid $5,000 or $10,000, he couldn't remember. He approached saying, let me refresh your memory at 11R323. When he met with Detective Thompson, again, let me refresh your memory with this transcript at 11R313. And so on, paralleling the direct examination. And of course, when the court decided to admit this hearsay and testimonial statements in violation of Mr. Clay's Confrontation Clause rights, Mr. Schaefer objected that you're only supposed to allow information in on the same subject under the rule of optional completeness, which did not include these remarks by Spratt. He asked for, a limiting instruction at the time. He objected every time the hearsay was offered, and we know under Rule 802, objected to hearsay cannot be probative evidence. He asked then for a limiting instruction at the end of the case as well, which is in the record. And as I said, because of his objections and because he asked for the limiting instruction at the time, that was directed towards his questions, and at the end, that was directed at the use of this as probative evidence. He did preserve that issue adequately in terms of whether the evidence should have been used. I will just say also the motion for mistrial was timely made, and it was response to the state putting in evidence a video that had been excluded, edited out, agreed that it should be excluded. And
Counsel, when trial counsel made the motion for mistrial, but then delayed obtaining a ruling, why is that not a waiver?
Because the court said that's fine with him, and the state did not object to the procedure at the time, Chief Justice Gray. It was agreed to by the parties. That's how they would proceed. And so because he timely objected, the court said that that's fine, and the state didn't object. That's not a waiver.
Did he ever get a ruling?
He did. Ultimately, when the court denied the motion for new trial, he also denied the mistrial.
Expressly, or are we arguing by implication?
I believe he did so expressly, Your Honor. I recall the judge talking about it, but I'll get you a record reference for that to make sure I'm correct about that, and we'll report it back to the court. Let's see. I don't have that in my notes when the court denied it, but I recall him talking about that because the state was raising it at the time during the motion for new trial hearing, suggesting there was waiver. So I believe he did expressly overrule it, and just want to advise the court that the state did say, I don't know how this can be cured because it was a big deal, suggesting numerous witnesses had implicated Mr. Clay was not the case, and that was not the case. And in fact, the prosecutor who was there speaking was worried that Mr. Clay would be acquitted. So we know that suggesting numerous witnesses existed when they did not made the playing of this. Other people implicated him, very important to the jury, and it was their first note they inquired about that video. So we know the jury, they argued it in closing, and it was the jury's first note at 13R77 inquiring about that video.
Okay.
So I say I'm out of time.
I need you to go back for a minute
Sure.
to the disqualification of counsel
Sure.
issue. As I understand it, based on the briefing, the counsel said, I have a conflict,
That's right.
at which point the trial judge disqualified her.
That's correct, Chief Justice Gray.
If she has a conflict, how is that error?
Because she was not going to examine that witness. Mr. Schaefer didn't have a conflict, and he was going to examine that witness and in fact have Ms. Freud leave the courthouse when he was questioning that witness, and he had no information from her about the witness, about his case. So she had a conflict with regard to one witness, not with regard to the representation of Mr. Clay.
That was between she and Schaefer. Were they law partners or are they coordinated on this case?
No,
How is
Mr.
he not also have a conflict?
Because they aren't in the same firm. He practices out of Houston in a separate firm. She has her own practice here in Waco. And so they didn't share information about her prior clients. He wasn't even aware about the prior representation until the motion for disqualification was filed, and he put on the record he had no knowledge of that prior representation.
How long prior to trial was the disqualification?
2 weeks prior to day of trial, about 17 days, a little more than 2 weeks after she'd been on the case, a year and a half, reviewed all of the witness interviews, conducted all of the discovery, was familiar with all the jail phone calls, and so it was a pretty devastating blow to trial counsel.
And did Schaefer try it alone then, or was another counsel
He
appointed?
engaged Melanie Walker, also from Waco, who testified she knew nothing about the case. When some jail phone calls came to her, she didn't understand the reason they were delivered to her, so she testified she had a great deal of trouble getting up to speed. But we know from disqualification law that talks about this being structural error in the U.S. Supreme Court here, that it doesn't matter that he also had other competent counsel. It's his counsel of choice that matters, that makes it structural error.
You're representing to this court that the two attorneys didn't discuss it. Is that somewhere in the record?
It is in the record, Chief Justice, I'm sorry, Justice Neal. It is. I'm not giving you a promotion.
I appreciate that. Not
Please.
sir. Not sir.
Sorry, Chief Justice Gray. I apologize.
I yield.
It's nerves.
If he'll stay, I'll move over there.
I can tell you from experience, I don't know if that's a promotion or not.
I understand, Chief Justice Rose.
So, all right. I know your time's expired.
So I will get you that record reference.
Are there any other of the issues that you want to spend, say, a minute on?
I just think that it was pretty important that Mr. Schaefer was not permitted to make his record at the motion for new trial. The wrong standard was given to Judge Johnson. He was told that Mr. Schaefer had to make a prima facie case to be entitled to a hearing. Appellate counsel for the state agrees that he needed only to state reasonable grounds to believe he could prevail. This was supported by Tyler Clay verifying the motion, and also by an affidavit from Ms. Freud covering many issues. And so he was entitled to that hearing, and believing he wasn't entitled to a hearing, Judge Johnson did not allow him to make offers of proofs on many of those issues. Thank goodness he did make a record about the prior representation, his lack of knowledge on it, but he was not permitted to make a record about the timing of getting to Quanah Gilmore's information about the late 404B notices, about non-disclosure of Brady notice of leniency deals and conveyance of plea offers, and whether those offers were conveyed. So that's another area where we have a law that says you're absolutely entitled to make those offers of proof, and he was not permitted to do so. So that would justify a remand to complete that motion for new trial.
That would just be an abatement for the hearing, and then it would come back up if the trial court, who is a different trial judge now, didn't grant the motion for new trial.
Yes, Chief Justice Gray. Yes.
Any other questions? All right.
Thank you.
You'll have 5 minutes for rebuttal, and we'll wipe down the lectern. Give us just a second. I never know whether you call them pulpits, lecterns, dais, you know, what it is, but that thing out there, we're going to wipe it down. This is the pulpit. I don't think so. You want to start with a minus 3.5 minutes, or you want to reset it?
It's your ball. I'll play as long as you want.
All right, you may proceed when ready.
May it please the court, counsel. I would like to start with an initial observation in reviewing appellant's brief and the record. It appears to the state that there are many references in the appellant's brief to points in the record that I believe are misrepresentations of the record. Specifically, I noted a number of references to various statements, allegations, claims by appellant's trial counsel as being for the proposition of actual evidence or rulings or holdings of the trial court. With that caveat, I would ask the court to independently satisfy itself as to the propriety of the record and the appellant's references to it, both in their briefing and in today's oral argument. I note that there are 22 points of error presented in this case. I have now 18 minutes to address those 22 points of error. It may be a better strategy, instead of me to begin a presentation trying to address all 22 points of error, to rather invite the court to shoot me any particular questions they have about any of these issues. I am prepared. It is a big machine with a lot of moving pieces. I feel that I can give some helpful information to the court in regard to all these points, but I think a better approach might be to invite the court to state specific concerns at this point.
We're concerned about it all.
All right.
I think your best strategy would be to follow her lead on greatest relief first, which is issue 16, and go from there.
Issue 16. In regard to corroboration.
Yes,
sir. Corroborating evidence needs to be presented to connect the accused to the crime.
why don't you summarize what evidence you think corroborates?
First off, the state's closing argument gives a summary of that evidence presented to the jury. Specifically noted were Mr. Spratt's phone records, which in the aftermath of the killing, he was identified as a suspect, and the police obtained his phone records.
And this is just the number of calls, it is not content of the calls.
Correct. It is.
Is there any evidence in the record that indicates that pattern of calls was different before or after, because these seem to have been persons that were acquainted that might have had, shall we say, business dealings?
Yes, that is the key element of that being corroborative, in that Mr. Spratt and Mr. Clay did not generally communicate until immediately before the shooting. The number of calls, the length of the calls, the location of those calls all indicated that there was a commonality of this murder event at the place that it happened immediately prior to. The timeline of events is that after the shooting, that communication ceased. There was not a prior pattern of communication suggesting that these were mere friends or acquaintances discussing the ball game or the weather or that sort of thing. The nature, the length, and the location of those calls suggested that there was an association between these two individuals for this particular purpose of committing this particular murder. primary corroborating evidence was defendant's own statement to the police that Joshua Pittman had robbed him. He made that statement in his own recorded police interview. Later in the interview, he pulls it back once he
How is that corroboration from Mr. Pittman's career?
that corroborates his motive as to why Mr. Spears, the court will recall, had made the statements during his interview with the detective that that Mr. Clay had shared the information that that Pittman robbed me. Mr. Spears also related an incident where they were at the defendant's smoke shop, and the decedent had come to the smoke shop under some suspicious circumstances, and the defendant had shared the thought that he's coming here to rob me after hours. He made that statement, the defendant made that statement to the investigating officer during his interview, which corroborates what Spears shared in regard to statements the defendant had made to him in regard to
a motive to kill Pittman. If that's corroboration of sufficient to involve him in the murder, given Mr. Pittman's career, my understanding is that there were a lot of people who thought poorly of Mr. Pittman.
That was an allegation, and that was a statement by defense counsel at trial. However, there was no independent evidence of anybody else having any kind of a vendetta or a reason to kill Mr. Pittman. That was an allegation that was not supported by any evidence. And it very well may be that in the dark drug world, there very well may be some people who had some sort of motive aside from Mr. Clay. But again, that was never entered into evidence. And again, we're looking at corroborative evidence. We're not talking about evidence that needs to meet a beyond reasonable doubt standard or anything of that nature. We're talking about something that is not a high threshold, that there's no precise rule that can be formulated as to the amount of evidence necessary to corroborate, and that corroborative evidence is to be viewed on review in the light most favorable to the verdict.
Well, Counsel, and I'll ask one more question and get off this. I heard you say that it corroborated what Mr. Spratt had said about the agreement to kill Mr. Pittman, but as I understand it, that doesn't corroborate Clay's involvement in the murder. That's attempting to corroborate an accomplice's testimony, and that doesn't get us there on corroboration of Clay to the murder. In other words, this is linking evidence. It has to be evidence that links Clay to the murder. It's not technically corroborating an accomplice witness's testimony.
Those corroborative points, and this is merely one corroborative point. There are additional ones. Altogether, the corroboration does show that link. That is one particular point, because the charge was murder for remuneration. So you have to have evidence. You have to prove that beyond a reasonable doubt with the evidence as a whole. You do need to corroborate any sort of accomplice witness testimony. And there are various points of corroboration in the record to show that corroboration to meet that standard.
Maybe it'd be best if we moved on to the counsel issue.
Disqualification of Ms. Freud. And again, a clear reading of the record would be helpful in the court's determination of that issue. The proposed witness, Mr. Mims, he was of the nature of Mr. Spears, what's generally referred to as a jailhouse snitch. Mr. Spratt had spoken to him, revealed some things to him in the jail, as well as Mr. Spears. The state anticipated calling Mr. Mims because he was from out of town. He was not associated with anyone in this case. And so the state felt that his testimony would be particularly beneficial. The state anticipated that it would be allowed to introduce recorded jail phone calls at the trial of the case. The trial court did not permit the admission of those calls, finding that the state had not turned them over timely to the defense and imposed the remedy of, we're not letting that in. Those phone records were, or those recorded jail calls were important because they showed a pattern of calls from Mr. Spratt to Mr. Clay during the period of his incarceration.
Are these the calls that Mr. Clay did not accept?
And he did not accept them. After Ms. Gilmore had been called upon by Mr. Clay to speak to Mr. Spratt on the phone and essentially tell him to shut your mouth. They're gonna put 2 and 2 together if you keep spouting off what you're spouting off to these people in the jail. You need to cool it. That after that happened, the calls stopped coming from the jail to Mr. Clay. And also his version of events that he had been sharing with Mr. Mims, they changed tenor. So the value of Mr. Mims' testimony was such. The state learned from Mr. Mims' counsel prior to trial that he was not going to waive the attorney-client privilege. That raised an ethical issue. And accordingly, the state filed the motion.
You say you learned it from his counsel. Who was his counsel?
I do not recall who his counsel was.
But it's not Ms. Freud.
No, it was. I believe that she had represented Mr. Mims, and I could be mistaken on this, but my vague recollection is she had represented him on another matter while he was in jail. And that his representation might have changed, or it might have been a different case.
She was not currently representing Mr. Mims.
No, but she was.
And he had counsel, other counsel.
That's my recollection. I could be mistaken. If I am, I'll send a clarifying letter to the court post argument. But the state, having learned that he was not going to waive that privilege that existed, and still existed as to those matters, filed the motion to disqualify Ms. Freud. That was the basis of that motion.
Had Mims been disclosed as a witness?
He had. And I believe it was assumed by all the parties that there was not going to be an invocation of that privilege by Mr. Mims, and the preparation had proceeded on that understanding. Once that conflict became apparent, it was an ethical issue that needed to be presented to the trial court. And the trial court called hearing on it. An investigating officer was called to testify. She was not prepared. The court called recess to allow the detective to review her case file before it could continue. During that recess, the court made an inquiry to Ms. Freud, inviting her for an in-camera discussion as to, what's going on here. And at that point, there were various remedies available, such as the suggestion that there be put a Chinese wall between Mr. Schaefer and Ms. Freud, that he do the cross-examination, that any impeachment of what he was saying be limited to prior convictions. A smorgasbord of possible ways to address the issue. Before the court could get to that, when Judge Johnson invited Ms. Freud in camera to discuss it, Mr. Schaefer objected to that proceeding. And Ms. Freud said to the effect, well, if he's going to be back there, I'm not going to say anything. I'm not going to violate that privilege. I don't believe that I can. And Judge Johnson noted, well, there appears to be that the two defense counsel are loggerheads here. And so he asked straight up, yes or no, Ms. Freud, do you believe that you have a conflict? She said, yes, I do. At that point, that's when the judge made the decision to disqualify. And that was based on her answer to that particular inquiry, and it didn't have anything to do with what the basis of the motion before the court was, and the court did not ever get it to determine what those issues were, because Mr. Schaefer would not allow his co-counsel to speak with the court in camera by herself. In regard to the claim that this was a ruse ginned up by the state simply to disqualify Ms. Freud, the record reflects the series of evidentiary rulings by the court in regard to the jail phone calls, the opening of the door to the recorded interview by Mr. Spears in regard to the state having presented sufficient corroborative evidence in regard to Mr. Spears' statement as the trial progressed to allow Mr. Spears to testify, and the door being open to the admission of his recorded statement, which coupled with not being allowed to present the jail phone call recordings led the state to make the tactical decision that, well, we don't need Mr. Mims at this point, and the effect of his testimony will be greatly diminished because we don't have the context of these jail phone calls to accompany his testimony. So a decision was made not to call Mr. Mims, and I find it interesting, if not downright funny, that the claim that by the appellant that, well, Mr. Mims was not a good state witness anyway. He proved up the defense's argument. Well, then why didn't you call him? You know, that belies the speciousness of this claim as to some sort of plot by the state to disqualify Ms. Freud.
Do we have in the record somewhere the fact that Mr. Mims not being willing to waive the attorney-client privilege with regard to Ms. Freud?
That was a representation that I believe the state's counsel made at the beginning of the hearing on that. I don't know if it was delved into. If he, no, I know that he never made that statement on record in this trial. And I think that I've touched on corroboration as well as disqualification.
Let me ask you, so you were talking corroboration earlier and pointing out other evidence that corroborated.
Yes.
The question I was going to ask you, so with regard to their issue 16, if Spears' testimony is out and the issue is sufficiency of the evidence to tie Clay to the murder, were the facts you were laying out for corroboration, is that kind of the full plate of evidence that the state had to overcome that sufficiency argument, or are there other things out there in the record that you think would help overcome the sufficiency argument?
I believe it's hand in glove. I think the evidence was comprehensive of showing the corroboration of Mr. Spears as to those he was offered money to kill Mr. Pittman.
As I understood the question, you correct me if I'm wrong, Justice Rose, assuming that Spears' testimony is out because we're trying to find the link, and obviously Spratt's testimony is out, Gilmore's may or may not be out, but what's left then for you to link if you can't use Spears' testimony? Did I rephrase your question?
Link Clay to the crime.
I think that the court is confusing, is assuming that any person associated with any of these people would be considered a co-conspirator, a co-defendant, what have you.
Well, that is the position that the state took to get part of their testimony into evidence.
In regard to,
And I think it was discussed in connection with issues 1 through 3 that was how the state argued the testimony was coming in by Spears and or Spratt, that they were co-conspirators and that it was a statement against their penal interest and therefore was admissible on the merits. But it wouldn't, if that's true, and that's what you argued and that's what you prevailed on, then we can't use that evidence in the linking process, or at least that's where the question is framed, is assuming we can't because they were co-conspirators as argued by the state to get the evidence in the first place. Where's the other evidence that we need to link Mr. Clay to the offense?
well, I would take a step further back in regard to the objection to Mr. Spears' testimony in regard to statements made by the co-defendant. The only objection was a confrontation clause, Crawford objection. So I don't think by any stretch of the imagination that you could characterize the co-defendant's statements to Mr. Spears as being testimonial by any means. In regard to the determination by the court, they did determine that Mr. Spears was an accomplice or a co-conspirator, and the corroboration requirement would apply to him. I'm thinking that the court's question presupposes that the other witnesses were also co-conspirators, and if that is not correct, they were independent witnesses.
Well, that's what we're looking for, is the independent witness testimony that is a link
Yes,
to the crime by Clay.
Yes, and I only touched on a couple of the corroborating evidence. I started off with the phone records. You have the defendant's own confession statement to the detective as to his motive as to why he would want to have the victim killed. You have Mr. Stewart's identification of Mr. Spratt as the shooter. That's all confirmed on video. And
there's where I have my problem. How does that link Clay to the murder? The fact that Spratt, well, everybody knows Spratt pulled the trigger that killed Mr. Pittman.
Yes.
That's not disputed.
Yes.
So how does having Spratt on video killing Mr. Pittman link Clay to the offense? I'm just trying to wrap to use a phrase, wrap my head around it. That
yes, there are multiple levels of corroboration and establishment of that element that that Mr. Clay did this with an offer of remuneration. And Mr. Spears' testimony was to that effect. The corroborating evidence does not have to prove beyond reasonable doubt any particular charged element. The corroboration comes in knowing that Mr. Stewart saw this interaction, the phone records showing the interactions, Mr. Spratt's statements to Mr. Spears in the jail, Ms. Gilmore's conveying the message to Spratt to keep his mouth shut, Ms. King's verification that the two communicants were in jail in the same time in the same circumstances that Mr. Spears testified to. They do not need to prove that particular element beyond reasonable doubt. They just need to corroborate his testimony, and those are corroborative issues. And that being corroborative, the jury was entitled to consider Mr. Spears' information that he gave as to what those communications from the co-defendant were. I'm at 26 minutes.
You done? You hesitated.
I did.
If
I'm
you,
done.
okay. Thank you, counsel.
Thank you, Your Honor.
Give us just a minute. Thank you, Jill. Counsel, you may proceed when ready.
May it please the court, to answer Justice Neal's question first, the court incorporated all of the motions, the motion to mistrial for all purposes, and ruled on the motion for new trial, incorporating that at 15R8, so he did expressly overrule the motion for mistrial. With regard to record references, I'm satisfied that I did make accurate record references in my brief and in the argument. I will say that what's important about linking or corroborating evidence or sufficiency of the evidence is what we know is that the phone records showing Spratt's in the vicinity of the convenience store really don't amount to a hill of beans, because he had a home there in that same neighborhood on the same street, as reflected at 11 record page 210. Donta Stewart, thank you, who testified about seeing him and identifying him, testified to that fact. I want to say about the Gilmore message, her testimony was, quote, "I told him he needed to quit talk, don't talk, phone no more. You talk too much on the phone, just chill. Wait until you get a bond reduction and we're gonna come get you, just chill. You say innocent, they put 2 and 2 together. This is on, it has nothing to do with the murder case," was her testimony. So she's telling them to chill, they'll put 2 and 2 together about your innocence, and that's what I was saying to you about the characterization of her testimony. But in fact, let's say that raises a suspicion about Clay. It certainly doesn't link him to commission of the murder or payment of remuneration, because there is no evidence in record that any money was exchanged between Mr. Clay and Mr. Spratt, or Mr. Clay and Mr. Spears. Mr. Spratt was quite busy on his phone. That's true. He had over 400 calls a day. There were 3 calls to Mr. Clay's phone from Mr. Spratt around the time that the shooting took place and after. That's at 10 record 260. And there were phone calls between Mr. Spratt and the decedent, 36 calls around that period of time at 10 record 239. no one would suggest that they were plotting to agree to his murder. It's just not corroborative at all. And the fact that Mr. Clay's smoke shop had been robbed, or perhaps that Mr. Pittman had attempted to do that. We had testimony from Donta Stewart as well that this man was known for robbing individuals, that he was disliked, in fact, that he had robbed Mr. Mr. Spratt in the past. And one of the things that Mr. Schaefer tried to get in was his past, that is the decedent's past record for sexual assault of a child, to point out that numerous people might have had a motive to have him meet his demise. So I would suggest to the court that absent the Spears testimony that was inadmissible and objected to hearsay and testimonial, there is no evidence that establishes Mr. Clay's guilt. In addition, or links him to commission of the offense, but from the sufficiency of evidence standpoint and from corroboration of the accomplice witness. And Judge Johnson, this is an 11 record, page 15, lines 6 through 9. Well, at this time, there's such a limited amount of information or evidence that would corroborate this in the record. I'm going to sustain the defense objection. And that's when he decided that Mr. Spears' testimony could not come in because Brett's information was not corroborated sufficiently to admit it in the case. With regard, I mentioned the other motives. At page 46 of our brief, we cite the Umstead case out of the Court of Criminal Appeals that stands for the proposition that proving motive is insufficient to corroborate an accomplice witness. So there's that authority in our brief at page 46. With regard to Freud, we have Alan Bennett was the lawyer that represented Mr. Mims. There was nothing in the record by Mr. Mims that he wouldn't waive privilege. Ms. Freud represented Mr. Mims for about 2 months in a case that he pled guilty to on the day that they were set for trial.
Counsel, if I could interrupt.
Sure.
When Counsel Freud represented to the court that she had a conflict, what was the trial court to do at that point?
Well, I think she could insist that she not be involved in the examination of Mr. Mims. That's the solution, and to satisfy himself that she hadn't imparted information to Mr. Schaefer, which was confirmed that that was available. And Mr. Schaefer did object to Ms. Freud going back to speak to the judge ex parte, because then Mr. Clay would have been unrepresented, because the lawyer conflicted as to him about that matter was no longer representing him with respect to it, and that's why he was concerned about that. And he offered all these other solutions that would have obviated the need to disqualify Ms. Freud and cause this structural error.
Were the solutions offered before the exchange in which Ms. Freud said she had a conflict?
Yes, Your Honor. The offer to stipulate on what Mims' testimony would have been, and then a record was made entering the motion for new trial, not before the exchange about examining Ms. Freud in camera. A record was made at the motion for new trial hearing with regard to the other remedies, but the fact of the matter was that was available also. If there's something further, I think, well, no, I'm not quite out of time. I'm a lawyer. I've got 24 seconds. I can.
Well, I bumped it a little bit, so.
You did. But I just do want to say that Mims' testimony was not helpful to the state, because he testified Clay was not involved and that there was no remuneration involved. He just had Spratt confessing to the offense to him. So it's not something we expected the state to put on. It didn't help their case. In fact, it helped the defense case.
Thank you, counsel.
Thank you very much.
This case is submitted and y'all are excused. And we're going to take a little break to sanitize the table to the podium, and we'll come back in about 5 minutes or so. And this is the casual part. We don't break in.
Okay, so we just hang out here.
You can either hang out or go to the restroom. I'm going to go to the restroom. Looks like John's set.
I'm gonna hang out.
Okay. John's going to hang out.
I want to give it a little
It's still.
Super weird.
It's changed.
I've been here now for, so I've been graduated for about 10 years. And then I've worked while in his office under Ranch for about 2 years. One of the longest serving ADAs in the county at this point.
That's great.
There's only one longer than he's been there since 1988.
You'll catch up soon.
I hope not.
That's very interesting. I like this details case.
It was fun. I did a lot of graduation.
Glad that you can tell me that beforehand.
I wouldn't.
Yeah, it's different when you're there, you know, you're like, I remember exactly.
You really
And
something.
there's stuff like that. Just before this qualification.
Oh my gosh. That's crazy.
Yeah, but that's before.
Yeah.
I'm late, I'm short time here.
Making sure I went to camp. Justice, how are you?
I'm well, how you doing?
It's been a while.
Good to see you.
I heard
Yeah,
you're not continuing.
yeah, May 31st. Retiring.
Well, this time I'm actually eligible. Last time I was not. You have to put it for, I don't know. It's no offense. Looks like fun. It's more fun to get this.
I understand. I understand.
I was telling.
I found it more fun to read this conference, so.
I feel like it would be too. I was telling her I have arguments on one of y'all's cases in the CCA next week in Baltimore, so it'll be fun. Well, I am sorry to see you guys.
Well, I appreciate it.
I've enjoyed it. I thought you guys have done a great job. But at least you never shall recommend for a comment.
That's true. That's true.
So.
Hey, why don't you have me? You involved in the process?
I did most of the arguments on one, but it was just one where I had a few other cases at the time.
Is that how y'all do the?
So typically, like, we'll have our list of what's due, and then we'll just, whatever the next one, like closest deadline is, you'll take that, I'll take that one, and then we just kind of, and we kind of alternate. But I don't take as many Sterling files as all of our civil cases. So there are forfeitures, bond forfeitures. I'm also in trial court a lot more than Sterling is arguing down there.
I was wondering how y'all do these stuff up.
Yeah, he does probably
I know.
around 65% of them, and I do about 35%, just because everything else I do.
Okay.
It's been
So your civil stuff, like civil forfeitures, things
civil
like that.
forfeitures, non-disclosures, expunctions, bond forfeitures, and then if something comes in for any case, probably somebody knows how to deal with it, I usually just. I'm kind of nobody knows what's going on.
Okay.
The jack of all trades. It's like,
Yeah. And I usually, I try to. Yeah, not.
And it makes sense. don't know.
That was
The short yard, stumbling in a report. The one who said she could come back. She played real killing. Anyway, the short hair. Yeah, I know.
In January.
That's not the right one. It's very, but I just think you don't try and go. Yeah. So she was that transfer, but she was it's huge.
I think most of the trial.
The other guy. I would be shocked to see this.
I like his frustration. Don't worry. It's gonna happen. Not yet. He is, he wants to phone in. Whatever you want.
Yeah.
Couple of things. Hot what?
And I don't know who
All right, man, it's good seeing you.
Please, have a seat, have a seat. All right, we've been sanitized and now we are ready to proceed with the second case on today's docket.
May it please the court.
Not yet,
Not
not yet.
We're not pleased yet.
I gotta get your papers up here. We're getting close, though. My apologies.
Not at all.
I'm not as organized as my colleagues here. And since we have taken a break and since it's been a moment since the announcements and we may wind up breaking up this video when if we link it to the case management system, both counsel, please make sure and introduce yourself and make mention of who your client is in the proceeding. At this time, court calls In re H.S. Hoke. Counsel Field on behalf of Hoke Ranch, and counsel, you may proceed when ready.
Thank you, Your Honor. Scott Field on behalf of H&S Hope Ranch with my co-counsel Bill Youngkin. If I could take a moment of personal privilege, I can say one thing that was mentioned during the CACA call. I last argued in person in a court of appeals in this court in January of 2020. It's my last oral argument in person, and this is my first one since the pandemic. So I'm pleased to bookend the pandemic for the Court of Appeals. And I think I speak for everyone here when I say we're glad to be back. And thank you for having us today.
Well, the technology, I'm going to put this on pause for just a minute. The technology was only made possible because we had some good help from our staff attorneys in testing it out. Jill Durbin, Rick Bradley, and another attorney that was with the chamber that wasn't able to or that was disqualified, Casey Kent, helped us get it set up so that we could do it because we were still restricting attendance. And so without the technology, which we think we will probably continue for the future in making it publicly available. But we are glad as well to have attorneys live. We can seem to get more out of it when they're present. So thank y'all for coming and agreeing to do it. If anybody had objected, we would have done it by Zoom, but we're glad to be able to do it live. So
thank you, Your Honor. May it please the court. This case involves the interplay between three statutes, and perhaps four. We'll get into that in a moment. But the three statutes are section 25.0003 of the Government Code, which sets limits on the amount of controversy a county court of law can hear. Section 21.001 of the Property Code, which gives concurrent jurisdiction in eminent domain cases for county courts of law and district courts. And then section 21.02 of the Property Code, which provides some exceptions, notably issues of title and any other matter that cannot be fully adjudicated by a county court of law. If either of those is present, the case must be transferred to the district court. Now, my goal today is to assist the court with that interplay of those statutes, see if we can't harmonize them and also give meaning to every provision within those statutes. And to do that, I think the best way to assist the court is to start with what we know, what we absolutely know, either through plain language of the statute or court interpretation of these statutes. And I'll get into each of these in more detail, but the three things we absolutely know. Number one, the 21.001 concurrent jurisdiction is not absolute. There are exceptions. Number two, a portion of a statute cannot be rendered meaningless by court interpretation. And number three, we also know that just because you file an eminent domain case in county court of law does not fix jurisdiction in that court. I'll start with the idea or the truth that 21.001 of the Property Code is not absolute. There are exceptions to that concurrent jurisdiction between county courts of law and district courts. And how do we know that? Well, we know that because this court said so, number one. And in Ray Riley, this court encountered an eminent domain case where an issue of title was raised, and this court held in a mandamus proceeding that the trial court used its discretion in not transferring that case. And this court conditionally granted the mandamus and ordered the transfer of the case to district court. The second way we know that's true is the AIC case out of the Texas Supreme Court, cited in our reply brief at length. In the AIC case, it's not on all fours, but it's close. To me, this is the most instructive case for this court in harmonizing these statutes. AIC involved an eminent domain case where the claim was made on the other side that the amount of controversy was too big and there was a title dispute. In other words, almost exactly our situation. And the Texas Supreme Court, to me, tellingly, did not go to 21.001. They went to 25.0003, noted that the amount of controversy is limited to 200,000 in a normal case. And then they went to 25.0001, which is on that exhibit I gave to the court. And 25.001 says, first of all, that this subchapter applies to all county courts of law. So that subchapter, meaning 25.003, is part of that subchapter. And then they said, unless, actually they didn't use the word unless, they used the word if a provision of the subchapter conflicts with a specific provision for a particular court or county, then that's not the case. So in AIC, what the Texas Supreme Court did is they looked at 25.003 and they said, well, although that would normally apply, we know it doesn't here because Harris County at the time had a specific statute that applied only in Harris County that gave concurrent jurisdiction to county courts of law and district courts over eminent domain cases, regardless of amount of controversy, specifically said that, and over title disputes. In other words, basically, legislatively nullified 2102 for Harris County. Now, some interesting observations from that. Number one, 25003 would have applied otherwise. And number two, why did the legislature say regardless of the amount in controversy if it didn't matter? And why did they say regardless of title disputes if it didn't matter? So we know, I think fairly, from that case, we believe the reasoning is not on all fours because what they didn't do is go to 2102 to that second part and say that this is a matter that can't be fully adjudicated. It never said that. And so I don't want to represent to the court that it's on all fours because this doesn't quite get to where our argument gets to, but it's close. And the reasoning fully supports our argument. The second signpost, if you will, that we know in interpreting these statutes is we can't have a meaningless provision in legislation. As a court, you're not allowed to say, well, that part doesn't really mean anything, or it's surplusage. And so if we look at 2102, the first part this court's familiar with, because in Ray Riley, you've applied it before. If an eminent domain case is pending and the issue of title comes up, you have to transfer it. But there's that second part. It says any matter that cannot be fully adjudicated in the county court of law. I can't find a case that interprets that language candidly. Just can't find it. And it's unusual because it's been there a while. But what does it mean if it doesn't mean what AIC suggested it would mean without saying so? What we suggest it would mean that there are claims besides title where a county court of law truly doesn't have concurrent jurisdiction with the district court. And we believe that that is the way these statutes can be harmonized. And so we know for one thing, it doesn't mean title, right? Because the first part of the statute says title. It has to mean something different than title. And we believe that portion of that statute is key to harmonizing these provisions.
Can I ask a question, maybe looking at that from the other side of the door? When the legislature gave concurrent jurisdiction to the county courts of law with the district courts, aside from the dollar limitation, what other hindrance would the county court of laws have had in having the same jurisdiction that a district court had?
So to me, Justice Rose, that is the primary hindrance. That's why I think that's what that means. I've thought about that, but what else can't they hear? And I'm sure there's a statute somewhere that I'm missing. The county courts of law can't hear a certain type of dispute that I don't know of. But honestly, I haven't found that other case. That's why I think it means what we say it means in this case. The third thing we know, and I'll be just probably overly candid with the court on this one, is that my light bulb didn't come on until I was preparing for argument. Justice Greenhill used to call that a mental sunrise, and mine came a little late in the game. And third thing we know is when you file an eminent domain proceeding in the county court of law, there's an argument from the other side that, well, once that's filed, there's nothing anyone can do to change that jurisdiction of that county court of law over the eminent domain proceeding. And we know from 21002 that that's not correct. And this is the part that was right in front of me the entire time I was writing the brief, but I really didn't clue in on it. 2102 says that an eminent domain case, if that eminent domain case is pending in a county court of law and an issue of title arises or an issue that cannot be fully adjudicated arises, then you have to transfer. It says if it's pending. So we certainly know that just filing an eminent domain case in the county court of law doesn't get you there. And so with those three things in mind, to me, the only way to harmonize these statutes is to say that if it's an eminent domain case and it's pending, and there's a counterclaim like ours that's over $200,000, now $250,000 with the change in the legislature, or involves title, which we, by the way, which you'll notice in our briefing, I think this case involves both. We've primarily made the argument about amount of controversy, but one of our claims is that because they're a bad faith trespasser, we have a constructive trust over the pipeline and everything in it on the property, which is a fixture, of course, on the property. So I think fairly you can look at that as an issue of title as well. We have made the alternative argument that at minimum, the counterclaim should be transferred. Now, I'll tell you statutorily that the trial court gets to decide whether it's dismissed or transferred. The statute in the Government Code, Chapter 74, gives the trial court the option. We've argued for transfer, of course. At the time, because we were concerned about limitations, I got involved in the case. I was worried about limitations. Since then, I've realized there's a savings clause. If you have a jurisdictional issue and a dismissal, and then later you refile it in the correct court, there's a 60-day window there for limitations. So that, anyway, the trial court has the option there. But we have Texas Supreme Court authority, even outside the eminent domain context, that if you have a counterclaim that's outside the jurisdiction of county court of law, they have to transfer or dismiss that counterclaim. Now, I will tell you that that's problematic in some ways, because if you think about it, if the condemnation proceeding continues in the county court of law, and our counterclaim goes to district court, the problem you've got is you could have an inconsistent judgment theoretically between the county court of law and the district court. That's why I think that argument is problematic, and I submit to you, it again is the reason we can harmonize these statutes, because if you look at 2102, I have to admit to you, I wondered, why does 2102 say transfer the case? In an eminent domain case, I think that's why. Ultimately, I think either the legislature knew or they accidentally got there. One of the two, as we both know that both of those things happen. The transfer of the case avoids those inconsistent judgments. And then finally, adequate remedy. We know that there is no adequate remedy at law in this case. This is not a simple plea to jurisdiction like opposing party has argued. This is in Ray Riley all over again. If there was an inadequate remedy in Ray Riley, there's an inadequate remedy here. Because what we have is that this is not your normal plea to jurisdiction where you've got sovereign immunity or some argument being made, and the choice is either you dismiss the case or you keep going. This is, as Ray Riley put it, an indirect conflict among two trial courts on jurisdiction. If we are correct in our argument, and we believe we are, then the county court of law is indirectly, not intentional, indirectly interfering with the jurisdiction of the district court over this claim. And this court and the Texas Supreme Court have said that in those circumstances, there is no adequate remedy of law.
I want to be sure that I understand one aspect of your arguments, and that I'll use numbers, and I apologize for that. I'm not a mathematician, but, and John Casey told me one time, don't ever do math in an opinion, and I try to adhere to that guidance. But let us assume that the condemnor comes into a proceeding asserting damages of, say, $98,000. The landowner or condemnee presents testimony that, or by deposition or expert report, that the property is damaged in the amount of $5 million. Does that case stay in county court at law?
It's a great question, and I think it's the CPA in you that won't let you lose the math part. It's a great question. I thought about it a lot, actually. And I'm not sure the answer, just candidly, but I think
let me ask it this way. Is that at all what you are arguing? That's $4.1 million is what puts it into district court transfer for you?
Yes, we have made a counterclaim for $13 million, and that is what we're arguing. Now, I think there's a question of title as well, but okay. It is a separate.
Wait, let me.
Sir.
Well, you said separate, so let me let you finish that sentence, and then I may ask my question.
Ours is a separate theory to reach that $13 million. It's not truly that we have a dispute over the taking of the property and that underlying soil is worth $13 million. That is not our claim. Our claim is because you put a pipeline in bad faith and you didn't have the right to, that as a bad faith trespasser, we own that pipeline and everything that goes through it. That's where we get to the $13 million.
So your $13 million, and by the way, we have been unable to find the expert report that is referenced in the record. So that's one issue that y'all need to be aware of. But, and y'all both made reference to it, but we couldn't find it. But your $13 million number, if I understood the briefing, it is not taking damages. It is trespass damages.
Correct.
Okay.
But you asked a very good legal question is, would it, if it were the taking, I've been thinking about that a lot. I'm not sure. I think there's a good argument that it has to be, but obviously it's not our case.
Okay.
And
So
I
that's
think
the answer to our math question.
It's not our case.
No, that there's a good argument that it has to be, because it's the take, right? I mean, it's the eminent domain.
right. It's the actual claim being made, and it's a dispute over what is the value of that land that's being taken. So, in our case, it's.
I mean, that's an easy way to get it out of county court every time. It's just make a counterclaim that either the property is worth more than $200,000 or that there's been a trespass or a conversion or a constructive trust or something like that, make a claim for more than $200,000. And not to get too far off subject, but that's almost like the previous case with the attorney. If you want an attorney off the case, just name a witness that attorney represented in the past, and it's
Right.
that attorney's gone. It doesn't seem right.
I agree with you. It doesn't seem right. It's kind of like the first time I read the TCPA, right? I'm like, what in the world is the legislature doing here? Because you look at it and go, how can this be the case? And I agree with you. It's a little different because here we have statutes that are guiding that. But do I agree with you? Yes, it's interesting because I actually believe that the rule is if you allege on the face of the counterclaim that outside the county court law's jurisdiction, it has to be transferred.
Now, go ahead.
No, sir, go ahead, please.
He's going to get up there and tell us that all those claims got dismissed. And before you get to rebuttal, maybe you could go ahead and.
On the TCPA?
No, on your counterclaims, that all your counterclaims are dismissed.
Right. The claim is that they were dismissed under the TCPA. And that was before I got in the case. I can assure you, if we were back in the county court of law, those are going to be revisited really, really quickly. Because with respect to Judge Sorensen, they're absolutely incorrect, number one. But number two, and I'd like to give her a chance to reverse that before we're back before this court. In Panchakarla, the Texas Supreme Court said a TCPA ruling is not final as long as the trial court has plenary power. So believe me, we will be revisiting TCPA. That's number one. But number two, it didn't dismiss. We had two claims at that time, fraud and conspiracy to commit fraud. Those claims, if you look at our current counterclaim, are nowhere to be found. Now, some of the facts are the same, of course, because we're claiming that Enterprise Products put in this pipeline for its own purposes, which makes it not a common carrier. They created a shell corporation, Rebuttal, to this purpose. And what these pipeline companies do is they create these shells. They get one other friendly company to.
That's getting off into the merits. Don't think we need to go there. So
Certainly, but short.
And I don't know that it's in the record now. If it's in the record, argue it, and if you want to, go ahead.
It's in our counterclaim, but you'll see that our claims now are not the same as they were when they had that TCPA.
Okay, so your second counterclaim is different than your fifth one, or your first one's different than your fifth one.
Right.
Okay.
But those counterclaims, are they within the nature of things that would be described as an eminent domain claim? Because they seem sort of like damage theories based upon the improper exercise of eminent domain. So when you look at the statutory concurrent jurisdiction for eminent domain, are these counterclaims putting some dollar amount? Are they in it or are they out of it?
Meaning in and out, or meaning compulsory or not compulsory?
Right.
I believe they were compulsory because it goes to the very right to condemn. But it's close. it's close, whether these could have been a separate claim in general. But I think the wise thing to do when Mr. Youngkin did it was to file the counterclaims. I think there would be a good argument there that it's compulsory. With that, thank you, Your Honor, I'll reserve the rest of my time.
Okay. We'll have one of our volunteers wipe down the podium. I'll be glad when we don't have to have that interlude.
Did they really volunteer or did you? force
So will the volunteers.
It was sort of an expectation of volunteers.
The Bill Murray character in a hazmat.
Counsel, you may proceed when ready.
Thank you, Chief Justice Gray. Tom Forrest here for the condemnor in the underlying case, the real party in interest before this court, Rebuttal LLC. The panel asked a lot of questions that I've been asking for the pendency of this mandamus proceeding, but it actually goes way back into the trial court proceeding. And in particular, this issue of, and really the assertion that this is the first case that a court has been asked to determine what 21.002 of the property code means. And I want to address that because Hope Ranch would like this court to believe that it's an issue of first impression. It is not. It is an issue of mistaken impression. In August of 2020, in our response to their motion to dismiss, and this is in the mandamus record, we cited a case in Burlington Northern Santa Fe Railway. It was a 14th Court of Appeals decision that dealt with the Fort Bend County court at law and a domain proceeding. And in that case, BNSF, who's typically the condemnor, was the property owner, and they were having land condemned. And they argued in that case that because of the relief sought by the condemnor, who I think was Fort Bend County, I may be wrong, but I think it was Fort Bend County, they were going to incur damages that exceeded the jurisdiction of the county court at law under the Texas Government Code 25.0003C, which at that time I think was $100,000. So that landowner goes to the trial court and says, what the condemnor is seeking in this case is going to cause me to suffer damages that exceeds your jurisdiction. And I want you to transfer this case to the district court. The holding of the 14th Court of Appeals was that 21.002, and specifically the second prong, any other matters that cannot be fully adjudicated, would not be interpreted by that court to allow BNSF as a property owner to seek a transfer to the district court. So to represent to this court that this issue has not been seen before, I think is incorrect. I think it's very incorrect. I think it has been decided before. We cited it in our response before this court.
What's the style on that case? Because that's exactly what I was just looking for, and I'm not seeing it.
Judge, let me get that for you.
Oh, I do see it now.
It's 12 Southwest 3rd, 891.
But that gets back to my math question, doesn't it?
Yes, sir.
And
Yes, Your Honor.
as opposing counsel said, interesting question, but that's not our case. Our case is we've got a trespass and other independent claims that we've asserted by counterclaim to $13 million. So it seems to be a different question.
Yes, and Your Honor, I would use a word other than interesting. I think it's frightening. The proposition that in any condemnation lawsuit, in any county court of law in the state, except maybe Harris County, where I actually happen to practice because they have a special statute that deals with eminent domain jurisdiction. A litigant, a landowner litigant, a defendant, could respond to a condemnation lawsuit at any time, maybe shortly after the filing of the petition, because they just don't happen to like the judge that the case has been assigned to. And they can respond to the petition under Hope Ranch's theory, assert a counterclaim, whether it's for the value of the taking and damages to the remainder, which we know is constitutional adequate compensation that they're entitled to. And by the way, there's an implied counterclaim in every condemnation lawsuit, because as the condemnor, we face strict liability. We have to pay something. That's what the condemnation lawsuit is all about. What is the adequate compensation? But let's say they take it the next step further and they do exactly what Hope Ranch did more than 2 years after the filing of the petition. But imagine this scenario. The petition gets filed with the clerk's office, the clerk assigns it to a county court at law, the property owner just doesn't like that judge, comes in and files an immediate answer, asserts a claim for $1 more than whatever the statutory limit is at the time under 25.0003 C1. Right now it's 250. At the time of the filing of this lawsuit, it was 200,000. But they file a counterclaim for $1 more. Under Hope Ranch's theory, they're entitled to an automatic transfer of the case to the district court. That scenario can play out during the life of the lawsuit. What about the litigant that decides, you know, maybe I don't like the judge, but let me see how this goes. I'm gonna keep my counterclaim in my back pocket, what I call the King's X. I'm gonna keep that in my back pocket until I think things are going south in my case. Until I see my opponent file a TCPA motion to dismiss. Until I see the judge grant that motion. Until I see the judge deny my motion to dismiss. Hope Ranch filed a motion to dismiss under 21.019C, challenging the power of eminent domain of Rebuttal, which every court has the jurisdiction to rule on under that provision. But what Hope Ranch decided to do was, when we filed our motion to dismiss under the anti-SLAPP statute in response to their first counterclaim, they immediately amended their counterclaim, filed a motion to transfer. King's X. The trial court granted our motion to dismiss. That's a ruling with prejudice. That's a dismissal with prejudice, and denied their motion to transfer. They then came back a year and a half later and filed with what I think is the 5th amended counterclaim, pleading for either, it's a little bit unclear, either 4 million or 13 million. I'm not sure exactly what it is, but I know it's a lot more than 200,000. And they asked for a transfer. Second bite at the apple, King's X. Needless to say, the trial court had been there and done that before and seen that, denied the motion. You could see this playing out hypothetically as what I would call an unintended consequence if this court were to adopt Hope Ranch's interpretation of the statutory scheme. A litigant could wait until maybe after a ruling on a motion for partial summary judgment on right to take, which trial courts adjudicate all the time. They could wait until maybe 8 days before trial, because Rule 66 allows you to amend your pleading without leave of court in the absence of a docket control order, 7 days before trial. What happens if they pick a jury and they don't like the jury? Or in trial, they don't like the jury. We know that trial amendments are allowed under the rules. They come in and they say, you know, we've been talking with our expert. It looks like our damages have increased. We'd like for you to transfer this case to the district court. And oh, by the way, county court of law judge, you don't get to evaluate the validity of my counterclaim because you don't have jurisdiction to hear it. And if you don't grant my motion to transfer to the district court, that's reversible error under NRA HNS Hope Ranch. So Chief Justice Gray, the question you've asked is directly, in my mind, the most serious question that has to be answered in this proceeding. It will open Pandora's box to not just forum shopping, but abusive forum shopping.
But isn't the remedy for that, one, you obviously could get the cure at the legislature if that became a problem, but in an individual case, if it gets to district court looks at it and says, these counterclaims are frivolous, there's no merit to them, so we're going to dismiss those, and because the county court and district court share concurrent jurisdiction over the eminent domain case, then they could transfer it back to the county court where the eminent domain case would be tried.
I think the district court would have the authority to proceed as you've described, Chief Justice Gray. The problem with that is that really a prudent use of judicial resources?
You know, the legislature writes things and we don't get to make that decision.
I understand. And that actually helps me segue into another point. In addition to disregarding in all of the briefing, I mean, I was looking at this yesterday. I think we've seen about 50 pages of briefing from Hope Ranch on the topic of the transfer question. We've had multiple hearings. I've already had 20 minutes of argument this morning. There's been no discussion about NRA BNSF, but there's another case that they've chosen not to discuss. And it's the Texas Supreme Court case of 1910, the Vance decision, which actually went to the Supreme Court on a very unusual procedural maneuver. It was a certified question from the Second Court of Appeals. We see it all the time from the Fifth Circuit over the Supreme Court, or you see it from time to time, but this was a certified question from the Second Court of Appeals. And in that case,
have you heard of this? Can we do that in courts of appeals?
Back before the Supreme Court is so important.
well, I was wondering, well, we don't see it anymore, and it looks like somebody did away with it. And I can imagine who it was, but in that case, the Texas Supreme Court looked at an 1895 version of the predecessor statute to 21.001 of the Texas Property Code, and also looked at an 1885 statute that preceded the 1895. All of these statutes, and these are laid out in our response brief, all of these statutes over time eventually led to the codification of the Texas Property Code in 1984. And we know that when the legislature codifies statutes, there's no substantive change intended, and there's no substantive change that should be construed in that statute. When you look at the Vance decision, it's a very short, the beauty of it, it's a very short decision on a certified question, but it states unequivocally that county courts at law have jurisdiction over eminent domain cases based on those two statutes without regard to the amount of money that is claimed or the amount of controversy. That has been the law in this state for 110 years under the Vance decision. It's been the law of the state by statute for almost 140 years. And so what Hope Ranch is asking you to do, and this ties into the comment, your last comment, Chief Justice Gray, is they're asking you to act like the Texas legislature and not just add words into 21.001. Add an implied restriction based on amount of controversy when there is no such restriction expressly.
But that's only, the Vance case, as I understood it, was my 4.1 million math question. That it was the damages that were involved in the take.
Yes, it's a little unclear. I would make the same assumption. It's a little unclear because the record is so abridged because of the nature of the way it got to the Supreme Court. But I don't think it makes a difference, Judge, under their theory. I don't think it makes a difference how or what the basis of their counterclaim is. And whether it's this trespass claim, which we know there is no trespass, bad faith or otherwise, in a condemnation case because of the Houston HLP versus Klein Independent School District case. That's in our brief. That's been the law for many years. But I don't want to spend too much time discussing the merits of their claims. I've already done that with the trial court. The trial court agreed with me.
To me, that's a spot though where there's a distinction to be made, and it's worth your while to do. I mean, I'm trying to figure out, are their claims some different animal than Justice Gray's example of the money on the tape that's beyond the jurisdictional limits, clearly?
I think that, if I heard Hope Ranch's counsel correctly, they're certainly interrelated, and this is how they're interrelated. They have not pled in this case for an amount of money for the value of the easement or any impact the easement might have on the remainder. That's the traditional adequate compensation model. But instead what they've done is they've challenged whether or not my client has a power of eminent domain. The interesting thing about that challenge is that they raised it in a motion to dismiss in June of 2018, invoked 21.019C, which at that point, the trial judge could have heard, could have denied it, in which case the case goes forward and all we litigate is adequate compensation. Could have granted it, and as we know from the express language of the statute, the trial court would have the authority to award legal fees, other professional fees like appraisal fees and photographer fees and other expenses incurred up to the date of the hearing. There is case law that suggests that the landowner is also entitled to make a claim for damage, other damages incurred. But their counterclaims as pled in this case for the $13 million are premised on the assumption that Rebuttal doesn't have the power of eminent domain. And I would submit to this court that those counterclaims are premature, they're not right, and they can't be litigated until that determination is made. And I heard a reference to whether or not their claims are compulsory counterclaims. Under their theory, their claims are not compulsory counterclaims because they don't fall within the jurisdiction of the trial court. And the solution, the remedy in all of this is, and I haven't found a law that supports this on point, but I think we agree conceptually. I think the appropriate thing to do is for the trial court to dismiss the counterclaims. They're the ones that chose to bring the counterclaims into this case. They should dismiss it. We've cited the Pinkard case. We've cited, I think, Kitchen Design is another case that's cited, maybe in both briefs. Stands for the clear proposition that when in county court at law, if 25.0003C1 applies, the appropriate action by the trial court is to dismiss a counterclaim that seeks an amount of money that exceeds the jurisdiction of that court. The law is also very clear that when jurisdiction is established with the trial court, it stays with that trial court, and nothing other than 21.002 in a condemnation case could come into play to divest the trial court of jurisdiction. I have to address the title question because they've also invoked the first prong of 21.002.
Before you move on to that, so under your argument there, you would have to go through the entire eminent domain proceeding before you then get to litigate whether the condemnor had the actual authority to do it.
You would, Judge, you would at least have to have a determination made by the trial court about the right to take the power of eminent domain, which is a question of law. It's usually ruled upon either by a motion to dismiss under 21.019C or a motion for partial summary judgment or a plea to the jurisdiction. So you typically don't wait until trial for that issue. Everybody wants to get that issue cleared up pretty quickly. Nobody wants to spend money fighting over the rest of the case if the trial judge is inclined to dismiss it for lack of, because it goes to the question. It goes to the trial court's jurisdiction. The trial court, if the trial court determines that the plaintiff condemnor doesn't have the power of eminent domain, the trial court loses jurisdiction. And that's why that issue is typically adjudicated as soon as possible.
So how do you adjudicate that issue if you have potentially damages in excess of the county court of law's jurisdiction?
Well, the trial court certainly, it's a It goes probably without citation, but the trial court has jurisdiction to determine its own jurisdiction. But it goes beyond that in a condemnation case because the legislature expressly said in 21.019C, we're going to let you, in fact, we invite you to determine right to take power of eminent domain authority in response to a motion to dismiss filed under that provision. And that's what Hope Ranch did. They invoked that provision. They asked the judge to adjudicate my client's power of eminent domain. On the title issue, I'll address it as simply as I can. Every condemnation case involves a title dispute. By definition, a condemnor wants to acquire title to a property interest owned by the defendant. And under Hope Ranch's theory, every condemnation case in county court of law should be transferred to district court. If that happens, you don't have to worry about the second prong of 21.002, because by definition, each and every condemnation case filed in the county courts of law ought to be in district court. And that just can't be the law. In Ray Riley, Chief Justice Gray, which you authored, dealt with the classic example. There was a fight between with third parties over who owned the land that the condemnor was trying to condemn. We don't dispute that Hope Ranch owns the property. They claim they own it, we claim they own it. That's why we named them. And the reason why the title issue has to be resolved is because the trial judge needs to know who is going to be named in the judgment that will be divested of the property interest that will be transferred from the property owner to the condemnor. That's why that issue has to be adjudicated. So for all these reasons, Your Honor, we would respectfully request that the court deny the petition for writ of mandamus and lift the abatement of the underlying case and allow it to proceed. This court has the full authority to fully adjudicate all of the claims in this case.
You good? All right. Thank you, counsel.
Thank you.
Shows how much I played. I didn't work with it. Thank you, Jim. Counsel, you may proceed when ready.
Thank you, Your Honor. Yeah, so I want to address the questions you asked and Mr. Forstier's responses to them. First of all, Burlington Northern, Santa Fe Railway. First of all, that case was mentioned in Ray Riley and with the designation of contra authority on the issue of title. I like this court, first of all, I don't think they got it right in that case, which really doesn't matter, of course, from my perspective now. I hate to say that because the author, Justice Fowler, I think was a fine judge and a really smart judge. But the key there in Burlington Northern was, number one, the condemnor was asking the court for an injunction, the county court of law for an injunction against the landowner to build a better railroad crossing for their condemnation. It was actually the condemnor asking for something to be done in invoking the constitutional authority of the county court of law to make an ancillary injunctive order pursuant to their jurisdiction over the over the condemnation claim. Totally different than our case. Totally different situation. Number two, it also involved a specific statute that related only to Fort Bend County. Just like I said on 25.0001, if you have a specific statute that relates to a court or county, that trumps 25.0003. That was the situation in BNSF. Secondly, this counsel said that every case involves an issue of title, and in some ways that is true. And I want to come back to Justice Rose, your question to me. You asked about compulsory counterclaims because I think it's a fair question. And I thought about it after I sat down. In Ray Riley was a case where the issue of title was actually pursued in a companion district court case. It wasn't a counterclaim. It was a companion district court case, and what the defendant in the county court of law came in with a plea of the jurisdiction and say, hey, we have the assignment issue, and we filed that in district court. You, county court of law, because of that issue of title, no longer have jurisdiction. It wasn't a compulsory counterclaim. At least that wasn't the procedural posture in that case. 1910 Vance decision, very, very, very different statute, first of all. Secondly, in all candor, I can't make heads or tails of what the court really decided in that case. But we know this, different statute, and as of I believe it was 2010 or 2011, the Supreme Court decided the AIC with allegedly the same issues did not reach the same conclusion that Vance reached. They reached the conclusion that the issue is all about Chapter 25 of the Government Code and whether it applies, and the only reason it didn't apply was a specific provision for a particular county, just like we had in the Burlington Northern case. And then I'll conclude with a comment that I'm asking you to be the legislature. I am certainly not. In fact, my guess is that if this court were to just look at this from a policy perspective, it wouldn't be comfortable with the relief I'm asking for. And I know that. I know I'm asking you to get out of your comfort zone. But as courts, that's what you often have to do, is look at what the legislature gave you and apply it and give it meaning. When we said that this was a case of first impression, it was very clear what we meant. That 2102's language, that any other matter that cannot be fully adjudicated in the county court of law, that provision has never been interpreted, and I would challenge them to find one that has. That is an issue of first impression. And this court has to make it. And I think the only way to resolve that issue of what that means is to look at AIC and realize that is what it means. There are other issues the county court of law can't decide in the eminent domain case. And under AIC, one of those is a counterclaim like we've made that alleges more than $200,000 amount of controversy. We asked this court to transfer this case to district court. Alternatively, we asked this court to order transfer or dismissal of the counterclaim. And we asked the court to conditionally grant mandamus relief. The last thing I do want to ask the court, though, is subject to objection from opposing counsel, may we supplement the mandamus record with that expert report that provides the $13 million. That was an error if it was not included in the mandamus record.
File a motion to supplement. That'll give opposing counsel opportunity to object if they want to, and we'll take that up. If it's necessary for the opinion, we certainly have you all's representation of what's in there, and that may be all that is necessary given the makeup of this case. One question before you leave the lectern podium. There are a bevy of words, and I probably should have asked you this question as well, opposing counsel. Forestier? Okay.
I, by the way, appreciated he introduced himself the first time I ever met him that way, and I've remembered it ever since.
Okay. There are references to cases, claims, and in other contexts, we talk about suit, issue, as opposed to, in other words, an issue on appeal, an issue in the trial court. Are any of those labels important to this case?
I think the only one that's truly important in this case is the word case. Case is not like claim. Claim we see a lot in the statutes. I keep going back to the TCPA just because it's on my mind. But there's an issue where we have a claim, a legal action or a claim used in that statute. This case is unusual. I don't see that many statutes that say case. And I think that is specific in that it means the entire case.
Okay, this is very rare. I don't think I've ever done this before, but do you have anything to add to that question? Since I did not ask you that question while you were at the podium.
If I understand the court's question correctly, I agree with them that the 21.002 uses the word case, but I think the question that comes out of that is that they're asking you to mandamus the judge, trial judge, to transfer the case when they didn't ask the trial judge to do that. And that's where then claims, counterclaims, and all of that. If you look at the record from the hearing on the motion to transfer, counsel expressly told the trial judge, I don't want you to transfer the case. I just want you to transfer my counterclaims. And so I would answer your question, Judge, by saying, I think the phrase counterclaim is important. I think claim is important because that's all they asked the trial judge to do. And now we're here.
Surely you don't want to go back down there and then have them ask the judge to transfer the case and then come back.
My client would hire another lawyer.
Okay.
In the interim, that happened.
All right.
Can I rebut that?
Yeah, sure.
We've addressed that in our reply. He's correct that we asked for transfer of a counterclaim, but this is an issue of subject matter jurisdiction. Anytime subject matter jurisdiction of a trial court or the Court of Appeals or any court is negated, that argument, you can raise that argument. We could have been sitting here arguing about transferring the counterclaim, and one of you could have said, well, Mr. Field, what about 2102? It says transfer the entire case because there's no jurisdiction. It's a jurisdictional argument. It can be raised for the first time. Would I have liked to have given Judge Sorensen a chance? Because I think she's a thoughtful judge and doing her best. I would, I felt that way when people would get to Supreme Court and make an argument that we never saw on jurisdiction on Court of Appeals. It's annoying. But it's the law that you can raise subject matter jurisdiction, the lack of it at any time.
Thank you, counsel. Thank you, counsel. This case is submitted. Y'all are excused. I didn't mention it in the criminal case, but I will mention it now. Any authorities that you cited that were not in your briefs have to be letter supplemented with citations by end of the week or end of next week. Given the circumstances, I'd prefer them by this Friday. So I don't know if y'all did or not. I know in the other case they did, and I forgot to follow up with that instruction. So thank y'all very much. Be careful out there. Y'all are excused.
Thank you.
Thanks.
Get that one over there.
I like the little Lincoln Douglas style back at the end.